Good afternoon, everyone. Welcome to Wasa Distance Education and NBV3E Aboriginal Beliefs, Values, and Aspirations in Contemporary Society. Today we'll start right in on lesson number 12. Please get all your assignments in as soon as possible. We're coming up to the Christmas break. Now, we're not quite half done the school year. There'll be roughly 3 weeks left of this semester when we come back. So that will be halfway done the school year. So um, try to get whatever you can in before Christmas, and I'll mark it for you and have it ready for you. I'll send it back as soon as we return around January 6th or 7th, in that ballpark. So the lesson 12 that we are going to look at today is the impact of colonialism. The learning goals translated into outcomes or yeah, what you need to do to be successful. You'll be able to explain the historical and present day significance of treaties. And there's three treaties we will look at, uh, two historical treaties, one recent, one quite a ways back, and then also the possibility of a third treaty in the future. But we'll talk about that later. You'll be able to identify when and where key treaties were signed. You'll recognize common features in Canadian treaties. You'll explain why First Nations and the Crown wanted to sign treaties in the first place and what they expected to get out of them. The key terms that we will uh, be um, aware of are colonialism, sovereignty, and a band. So, I have three videos that I'd like to play for you. We won't do them all, watch them all today. Um, we will split them up between today and tomorrow. Um, but first, we'll read some text here from the unit, and that's on page 9. The impact of colonialism is our first topic. Colonialism is a relationship between two peoples in which one group takes over the lands of another and imposes on those people its traditions. So when French and English explorers and traders arrived in what is now Canada, Nations people met with them on a nation-to-nation basis. The First Nations had sovereignty over their lands. Sovereignty is a nation's supreme power within its borders. At first, peace and trade alliances were formed, and the First Nations became allies to the English and French. In 1763, after the American War of Independence, and again after the War of 1812, the value of First Nations as allies diminished. When the colonial powers arranged treaties between each other, these treaties did not involve the former First Nation allies. Also, promises made to First Nations in earlier treaties by the British were ignored. And that particular treaty that was ignored was I believe it was the British North American Act. Um, and that was written way back in the, 16th or 17th century. Not 16th, 17th or 18th century. Um, and, but when Britain got kicked out, it also included the United States, right? Because the United States was under Britain at the time, And when the British got kicked out, then that treaty was kind of went up in smoke. But the treaties that we are going to uh, um, refer to in this course are somewhat some more recent. There's the Indian Act. The Indian Act of 1876 was designed to control every aspect of the lives of First Nations people by creating bands and establishing reserve lands. This act separated Aboriginal peoples, changed government structure or governance structures, outlawed spiritual practices, changed the place of First Nations women in society, and made attendance at residential schools mandatory. Under the imposed band system, each band would elect one chief and up to 12 council members every 2 years. The federal government could overturn any election result, and any resolution made by a band council had to be approved by Indian and Northern Affairs, which is now called Aboriginal Affairs and Northern Development. Of course, this caused much conflict between the federal government and the already existing councils and chiefs. In some nations, the historical and the imposed systems of governance were able to coexist, but in others, the Aboriginal system of governance was pushed aside. The Haudenosaunee Confederacy was able to survive an attempt by Prime Minister Mackenzie King to have it dissolved. Over the years, changes have been made to the Indian Act and attempts made to abolish it. On pages 202 and 203, read about the uh, 1969 white paper introduced by Prime Minister Pierre Elliott Trudeau and the response to that document named the Red Paper. Harold Cardinal, a Cree writer, activist, and leader, wrote a book titled The Unjust Society, which was a direct critical response to the white paper. Okay, so I think Chrétien was also involved in that white paper way back then. It's all kind of history right now. Uh, uh, Pierre Trudeau and the Liberals back in the 1960s and 1970s. So, hmm, well, let's see. I don't have the actual text here. Where are we? There we go. Okay, so what do we need to look at? We need to look at pages 202 and 203. Oh, yeah, and the reading is from 198 to 210. So let's take a look, specifically at where'd you go? 2002 and 2003. Don't forget to read all of the suggested readings here. Uh, Here we go. 2002. Here it is, right here. This article. And 2003, the red paper. Okay, so in 1969, Pierre Elliott Trudeau and his Liberal government issued what they called the Statement of the Government of Canada on Indian Policy. Also known as the White Paper, it proposed to abolish the Indian Act. Okay, and the White Paper outlined the Indian Act as dated and oppressive and something that kept First Nations and Inuit peoples apart from other Canadians in ways that did not allow them to prosper. The government stated that without the Indian Act, First Nations and Inuit peoples would have the full benefits and services that many Canadians took for granted. Without reserves, First Nation people would join the larger Canadian community, and it would be easier for them to take part in education and training, to find jobs, and to prosper economically. This document was part of Trudeau's vision of a just society, one in which all peoples in Canada could have equal benefits and opportunities. However, the price of implementing the white paper would be the end of treaty agreements, treaty rights, and the unique status of First Nations and Inuit peoples. The reactions of many First Nation peoples to the white paper was negative. Many saw the white paper as a means of terminating or assimilating Aboriginal peoples, not helping them. The government would later withdraw the white paper. Read the main points of the white paper and the possible consequences in the chart below. So, the legal structure. Number one, legislative and constitutional basis of discrimination must be removed. So the consequences would be the Indian Act would be abolished. Number two, the Indian cultural heritage. There must be a positive recognition of everyone of the unique contribution of Indian culture to Canadian society. So instead of trying to assimilate Aboriginal peoples, the importance of Aboriginal peoples would be acknowledged. Number three, programs and services. Services must come through the same channels and from the same government agencies for all Canadians. Services would come to Aboriginal people through provincial and territorial governments instead of through Indian and Northern Affairs Canada, a federal department. Number four, enriched services. Those who are furthest behind must be helped most. The outcome or the consequences, Aboriginal peoples would be helped not because of treaty obligations, but for humanitarian reasons. And then number five, claims and treaties, lawful obligations must be recognized. While the document acknowledged the importance of historical treaties, once they were settled, First Nations people would be discharged from all treaties. And then the sixth point, Indian lands, control of Indian lands should be transferred to the Indian people. Consequences, First Nations people would be given complete ownership of the lands and could sell the land as they wished in the future. So that's basically the main structure of this white paper. And you can see some holes in it already. Well, for one thing, there's some gray areas here. You wouldn't know where, once you lose the things that you have from the Indian Act, and then you're really not sure if these consequences will ever be achieved. So you give up your treaties, and you don't know what you're going to get back in return, right? So now we'll read the red paper in a bit here. First, I want to play a video for you, and then we'll come back to that, okay? So, okay, let me tune that up for you. It's not that one. That's to come in the future. Okay, the Indian Act, its ongoing impact on First Nations. Let's read this. Read it. Watch it.
The relationship between the federal government and First Nations, it's still founded on a piece of legislation that is extremely colonial and where the Minister of Indian Affairs still has ultimate authority over us and our land.
The Indian Act is federal legislation that shapes the relationship between the Government of Canada and Indians, who are now known as First Nations.
The Indian Act was introduced in the 1800s as a piece of legislation that was essentially meant to, and effectively does, govern really every aspect of First Nations life.
I don't think there's any kind of other piece of legislation in Canada that really has any parallel, which has really kind of been used for over 150 years to define a relationship.
A lot of the colonial statutes and policies and laws that were in place at the time to structure that relationship between the First Nations and the British government were consolidated in the mid-1800s into a single act. When Canada became a country, it became the Indian Act.
The Indian Act had several objectives, but its main purpose was to control First Nations and forcibly assimilate them. This is evident when you look at the legislation it's based on. 1755, British officials created the first Indian Department to manage their relationship with Indian nations. 1763, in the Royal Proclamation, where King George III claimed North America as a British territory, he also stated that Indian lands could only be acquired by settlers if first ceded to the Crown. 1850, the Act for the Better Protection of the Lands and Property of the Indians in Lower Canada introduced early legal definitions of who qualified as an Indian. 1857, the Gradual Civilization Act encouraged Indians to enfranchise, meaning to give up their Indian status. 1867, Canada became a country and assumed jurisdiction over Indians and lands reserved for the Indians. 1869, the Gradual Enfranchisement Act aimed to forcibly assimilate Indians by removing Indian status from women who married non-Indian men. 1876, the Indian Act came into power and consolidated previous laws respecting Indians, continuing the goal of enfranchisement, the management of Indian reserves and monies, and setting rules for the Chief and Council government structure.
Colonial minds came in and said we can't have First Nations operating on completely different principles in our territory than the ones that we're trying to promote: white supremacy, patriarchy, capitalism.
It was a mode to control almost everything that we did and where we were and open up the land in this whole racist idea of European superiority.
It became an instrument for ensuring that the governance structures of First Nations themselves were harmonized with the gradually developing governance structure of the country of Canada.
Once the Indian Act was established as law, it became increasingly more oppressive, which is evident when you look at some of the early amendments. 1880, the Department of Indian Affairs was created, increasing federal control and oversight over First Nations peoples. 1884, the potlatch ceremony was outlawed, setting a precedent for policies banning religious and cultural freedoms. 1906, the Governor General was given authority to establish industrial or boarding schools and make rules for the arrest and detention of truant children. 1927, Indian Affairs was given authority to enfranchise Indians without consent. 1927, it became illegal for lawyers to obtain money to pursue Indian legal claims. There are over 630 First Nations bands and more than 3,390 reserves across Canada. They form 50 different nations, each with their own languages, cultures, laws, and traditional governing structures.
What does it mean when all of those diverse forms of government, of citizenship, of belonging are replaced with this? What does that do to your sense of self, your sense of community?
You replace that with an Indian Act system where it's populated by people who have been convinced of the assimilation agenda, who are tied economically to the development of industries that are prominent businessmen that are assimilated culturally, and you make them the chiefs instead of the people who are tied to the land, and you get what you want. Now the native people in a lot of situations don't have an alternative, and therefore they're dependent on this system.
Due to First Nations advocacy, the Indian Act was amended in 1951 to remove some of the more oppressive laws. But at the same time, the government established an Indian registrar to enforce stricter rules on Indian status. And despite numerous amendments since, the Indian Act is still problematic, not only for what's in it, but also because of what's missing from it.
Social assistance, housing, child welfare, policing, like all of these, what we now see as essential services. There's absolutely nothing in the Indian Act at all on any of those. Water as well, emergency, infrastructure, nothing. Neither the federal government nor the provinces wanted to have to provide these services to First Nations. It has allowed both governments sometimes to not to provide the service at all, or to provide a much more watered down, inadequate version of the services that other people rely on.
Not to mention, the Indian Act disempowered First Nations governments, stripping them of the authority and resources required to provide adequate social services for their citizens. Yet repealing the Indian Act may not be as easy as it sounds. 1969, Prime Minister Pierre Trudeau and his Minister of Indian Affairs, Jean Chrétien, introduced the White Paper on Indian Policy, aiming to abolish the unique legal relationship between First Nations and the federal government by repealing the Indian Act, dismantling reserves, and ending treaties. This proposal was met with significant resistance from First Nations leaders across the country, sparking a new era of First Nations political organizing and advocacy in Canada.
Indigenous people saw this for what it was an attempt to assimilate us, and so they fought to keep the Indian Act in place. We will use every tool in the toolbox in order to assert our rights and to continue existing, and if that includes having to use Canada's system of law for whatever advantage we can, we do. And I think that that is a real beautiful part of how we continue to fight colonization.
First Nations' vision, of course, of self-government is of them controlling their own land by their own laws to live out their own culture with their own priorities. Canadian government may say that it is giving up the assimilative objective, but it still is quite intent on maintaining the basic level of control it has over so-called Indian lands and the membership of people in Indian communities and of the types of government that Native people can have to run their own affairs.
The Indian Act has also interfered with First Nations' right to self-government and the right to set their own citizenship rules. In fact, current Indian Act provisions on status risk the legislative extinction of Indians unless amended.
Until 1985, the provision that if a First Nations woman married a non-First Nations person, they would lose status, their children would lose status.
It's not just holding a card. It's the right to live in a community. It's the right to vote in a community, to be a part of that community in really every active sense. And so the Indian Act for many, many years and many generations dispossessed Indigenous women deliberately.
In the 1980s, Sandra Lovelace Nicholas won her case at the United Nations Human Rights Council, condemning Canada for removing Indian status from women who married non-Indian men. In response, Canada enacted the Bill C-31 Amendment in 1985, restoring status to women who had married out. But unlike the children of men who had married out, the children of these women received only half status, diminishing their ability to pass status on. The amendment also introduced what's known as the second generation cutoff rule, meaning the loss of status after 2 generations of marrying out, continuing the agenda of forced assimilation.
One of the things that the Indian Act has done by its definition of status has made us be seen as a race. We're not a race, we're a people. And people belong to a group based on things like acceptance, but also loyalty and fidelity to the group and sharing the same sort of values of the group. But if we only go to ancestry and blood, we are playing into a system that sought to purposely racialize us for the purposes of our extinguishment.
As bad as the Indian Act is, it should be understood within the larger policy context. Federal and provincial governments have implemented other laws and policies designed to oppress, dispossess, control, and eliminate First Nations, including the illegal pass system, which confined First Nations to reserves, the 60 scoop forced adoptions, the establishment of Indian residential and day schools, and Indian hospitals, where many children were taken. There were forced relocations of communities, forced sterilization of women, and starvation policies, particularly on the prairies. These laws and policies have been recognized by the National Inquiry into Missing and Murdered Indigenous Women and Girls as constituting historic and ongoing genocide.
We're going to have to unlearn the ways that the Indian Act has affected our sense of self, our sense of community, talk about things like patriarchy, relearn what our governance systems looked like, think about citizenship in a more fulsome way than the Indian Act has allowed us, so that when we do win in those court battles, when we do dismantle the Indian Act, we are able to put something in its place that is actually meaningful and worthwhile and representative of who we are as a people.
We don't want to just replace the Indian Act with another framework for dependency. What I think should happen with the Indian Act is that the federal government should commit to the re-empowerment of traditional governments so that our people can begin to develop the capacity to have a system of government to govern our affairs, to govern our land, and to represent us to the outside world, which is true to ourselves.
While most First Nations would agree that the Indian Act is a racist, outdated piece of colonial legislation, many have cautioned against repealing it without first establishing protection for their rights and their special status in law. First Nations have made many suggestions, which include negotiating self-government agreements, amending the Constitution, and implementing First Nations laws. Whatever the solution, the lesson learned from the 1969 White Paper is that Canada should not do anything without First Nation consent. In other words, nothing about us without us.
People are almost sometimes frozen in a state of, it's not my issue, not my problem. Colonialism is all of our problems. Don't cop out, don't take the easy way out, learn, ask questions. Reconciliation does take everybody.
Okay.
You can say all you want about reconciliation, you can say all you want about decolonization, but that act is still enforced every single day.
Okay, sorry. That's by TBO actually, and it's well done. Um, yeah, so boy, we went through a number of different oppressive acts on Indian people from hundreds and hundreds of years ago right up to this present day. Right, and you can see that, well, people are a little wary of changing the Indian Act for something else, like what the white paper had suggested, because, well, traditionally there was, um, uh, it was all the changes that ever happened were all about assimilation, and that's what the white paper seemed to have hidden there in its wordings. So, yes, people uh, want to do better than that. First Nations people want to do better than that. But right now, there's no other structure or no other framework to move into. Though I do have a video on a video that we'll look at with some people, intellectuals, who are discussing um, how they can change the Constitution, and make a First Nations Constitution. But we won't look at that right yet. Um, let's see. So there, I do have another video here on the Constitution, and we should watch this one as well. Okay. Now, yeah, voice is a little low, but it's important to understand all of these uh, enactments by the Canadian government.
Part 4 of the Constitution of Canada on Indigenous rights. In this video, we will provide you with a general appreciation and overview of how Indigenous rights are recognized and protected by the Constitution of Canada. Remember, in 1982, the Constitution of Canada was repatriated from the United Kingdom to Canada. As a part of that process, the Constitution Act 1982 provided us with the Canadian Charter of Rights and Freedoms, but also within the Constitution Act 1982, there is a recognition of the rights of what are referred to as Aboriginal peoples of Canada. The more appropriate modern term for Aboriginal is Indigenous, and that is the term that we will use in this video. In subsection 35(1) of the Constitution Act 1982, it explicitly recognizes and affirms the existing Indigenous and treaty rights of the Indigenous peoples of Canada. Indigenous peoples of Canada includes what are referred to as Indian, Inuit, and Metis. Indian is more appropriately referred to today as First Nations. First Nations peoples are those who occupied the land south of the Arctic before the arrival of the Europeans. Inuit peoples are those who occupied the Arctic, and the Metis are people of mixed Indigenous and French ancestry who developed distinct customs and cultures. So what are the rights protected by Section 35? There are two types that are mentioned in subsection 35(1), treaty rights and Indigenous rights. Treaty rights are the rights contained in treaty documents entered into by Indigenous peoples and the Crown. Indigenous peoples are made up of First Nations, Inuit, and Metis. The Crown refers to the British King or Queen, especially if it's before Confederation in 1867. the Crown also includes the Canadian Parliament and provincial and territorial legislatures. Indigenous rights is a broader category of rights, which are collective rights held by Indigenous peoples that reflect their original use and occupation of the land. These rights may vary and may include title to land, self-government, resource exploitation, and culture and customs. The Supreme Court of Canada has said that Section 35 imposes a duty to consult on the Crown. This came from the decision of the court in the Haida Nation and the British Columbia Minister of Forests. In that decision, the court said that the duty to consult is a part of the ongoing process of reconciliation between Indigenous peoples and Canadian society. The court said that the duty to consult requires the Crown to consult with Indigenous peoples whenever it intends to act in a way that may adversely affect Indigenous rights. That duty to consult may be also delegated by the Crown to business interests. An example could be a company seeking a logging permit may be directed by the provincial government to consult with the affected First Nations to discuss the impact of the project and to negotiate a plan to accommodate Indigenous interests as a part of the process of obtaining that logging permit. What exactly does the duty to consult require in any particular situation? That's a very difficult question to answer, but what we do know is that it depends on two things: the strength of the Indigenous rights claim involved and the seriousness of the harmful impacts. On the low end of the consultation scale, where a weak claim and minor impacts are involved, providing notice to the affected Indigenous groups with relevant information may be enough to satisfy the duty to consult. On the high end of the consultation scale, where a strong claim and serious impacts are envisioned, then a deep consultation involving two-way dialogue and participation of the Indigenous groups in the decision-making process may be needed. As well, accommodations may be required. Accommodations are adjustments or modifications to a project in response to Indigenous concerns. For example, if a certain geographic area is seen to be culturally sensitive by Indigenous groups, an accommodation may be needed to have the project avoid those areas altogether. The Supreme Court of Canada has specifically said that the duty to consult does not give a right to veto to Indigenous groups. The duty to consult is best seen as being aimed towards a reconciliation of the rights enjoyed by the people who traditionally occupied the land and the right of the Crown to govern all Canadians. A good example of the duty to consult and the difficulties that arise from that duty is the Trans Mountain Pipeline project that was proposed by a company named Kinder Morgan. Kinder Morgan needed the approval and permission of the federal government in order to proceed with the project. The federal government delegated the duty to consult with Indigenous groups to Kinder Morgan. After Kinder Morgan had finished its consultation process, the federal cabinet approved the Trans Mountain project. However, certain Indigenous groups challenged that approval in court. In the decision of Tsleil-Waututh Nation and the Attorney General of Canada, the Federal Court of Appeal quashed the federal government's approval of the project on the basis that the duty to consult had not been satisfied. Specifically, the court said that the federal government had been closed-minded and unwilling to engage in a meaningful two-way dialogue with Indigenous groups. Due to that court decision, Kinder Morgan decided to stop the project, to suspend construction. The federal government then decided to take on the project itself. It bought out the project from Kinder Morgan for $4.5 billion. The federal government then restarted the consultation process again. After finishing a more extensive consultation process, the federal cabinet again approved the project, and that approval again was challenged in court. This time, the Federal Court of Appeal upheld the approval, saying that the duty to consult had been satisfied. The Trans Mountain Project, at the very least, tells us how difficult it is to ascertain exactly what is needed to satisfy the duty to consult.
Oh, excuse me, there's an advertisement. Oh, I'll skip this. Oh, yeah, I guess that's it, right? So that's fascinating, don't you think, to listen to like the legal wrangling of and how the interpretation of um, enactments like the Constitution, uh, uh, how these are understood and how they go through the Supreme Court of Canada and how they make their decisions. You can see there's a lot of gray areas there, for sure. And okay, so let's escape out of there. Right. So now let's look at the red paper and what we have about that. Boom, boom, boom. Oh, where is that? Oh, here. There it is. It's in our reading on page 203. Okay, so let's read what the First Nations came back with as an alternative um, or criticism of the white paper. The red paper, the once again, it's on page 203. The white paper was met with fierce opposition from First Nations who had never been properly consulted on the issue. Also, many First Nations people were upset that the government proposed to terminate treaty agreements. Rather than passively accepting these proposed changes, First Nations leaders spoke out strongly, particularly through the Red Paper, which was created by the Indian Association of Alberta, led by Harold Cardinal. Harold Cardinal, a Cree writer, activist, and leader, galvanized the political actions of First Nations people during the 1970s. His best-selling 1969 book, The Unjust Society, was a personal, direct, and very critical response to the white paper. Opposition provided by the book provoked by the book, along with the 1973 Calder case, which affirmed Aboriginal rights in the courts, is credited with influencing the Trudeau government to abandon the proposed policies of the White Paper. After the White Paper, First Nations continued to assert their right to be involved in national decision making. In 1980, when faced with upcoming changes to the Canadian Constitution and the political effects of those changes on Aboriginal rights, First Nations activists organized a peaceful protest called the Constitution Express. Led by Chief George Manuel, the Express was made up of two trains that traveled from Vancouver to Ottawa, collecting 1,000 passengers along the way. After protests took place in Ottawa, a smaller contingent of representatives went on to the United Nations in New York and then to 5 countries in Europe, where Aboriginal leaders gave speeches and brought international attention to their cause. Okay, right. So, now we might as well read on. I think. Okay. Just wanted to check the videos. Yeah, so we have looked at the Constitution. Um, in the previous video, and now we will read something here and that's found in the unit, and then we will have a look at the text, the reading for the text. Okay, so the Canadian Government Constitution Act on page 10. The Canadian government gained control of its constitution from the British in 1982 under the Constitution Act. Canada's Aboriginals were concerned about this act giving the Canadian government the legal right to implement legislation without British control because the treaties had been made with the British. Would the Canadian government honor the treaties? And you can see there's mistrust there because of the past. The courts have had to define what treaty rights are on a case by case basis. First Nations people continue to seek their own methods of governance despite the rules around the Indian Act. Organizations such as the Assembly of First Nations and people like George Manuel, Ovid Mercredi, Matthew Kuncum, and Phil Fontaine, and many others have achieved much success in their fight for First Nations peoples. They provide their voice in federal, provincial, and territorial politics. They are working toward regaining self-governance. And so we'll take a look and see what the text has here, and that might just finish us off for today. So there will be no key question to complete for today, but you have lots of work from that we've assigned previously here. Your homework will be to read the assigned um, pages here that were. I'll go over them again when I'm finished reading through this. The Constitution Act, the Canadian Constitution. Oh, this is on page 204. The Canadian Constitution was patriated in 1982 by the government of Pierre Trudeau. This patriation gave the Canadian government the legal right to implement legislation and increase its independence from the British Crown. For many Canadians, this was a welcome move, representing a new phase in Canadian history. Among Aboriginal peoples, however, there was less enthusiasm. The concern of First Nations people was relatively simple. The treaties had been made with the Crown. Would the Canadian government still honor the treaties? Many leaders, including Noel Starblanket, Fred Plain, and John Tutusis, lobbied hard for the inclusion and protection of treaties within the Canadian Constitution. Treaties were eventually included in Section 35, which was brought up in the video, but actual treaty rights were not listed or defined. This has resulted in Canadian courts having to define what treaty rights exist on a case-by-case basis. The government introduced amendments to the Constitution with both the Meech Lake and the Charlottetown Accords. The Meech Lake Accord of 1987 recognized Quebec as a distinct society. First Nation leaders argued that the accord ignored Aboriginal peoples as founding nations. A Cree member of the Manitoba legislature, Elijah Harper, was instrumental in preventing the ratification of the Meech Lake Accord. Harper stalled the decision in the Manitoba Parliament and refused to consent to a vote. Because the accord could be passed only by unanimous consent of the provinces, this refusal led directly to its defeat. The federal government addressed the country's constitutional problems again in 1992. The government, the Assembly of First Nations, the Native Council of Canada, the Inuit Tapiriset of Canada and the Métis National Council met in Charlottetown, Prince Edward Island, and agreed to a new accord. This accord addressed the unique issues of Quebec and also recognized the Aboriginal rights to self governance. Although the accord had won favor with the politicians, it was rejected by Canadians voting in a referendum. Okay, so we covered quite a lot of territory, historical territory today, and looked at politics, um, the politics from um, many years ago, and I made a mistake. The British North America Act. That was the no, that's what I said it was, but it was called something else. It was the original um, act that Britain had made when they took over and they beat the French uh, uh, and I don't have it straight. Well, that's okay. Um, it was the original um, uh, agreement that was made, and if you look at that agreement, they had um, basically there was the land that the settlers it dealt mostly with the eastern part of the United States. You know, uh, they looked like they were trying to protect the indigenous people um, because there was all kinds of statements they were saying that their lands were to be protected, and it really was most of the country, um, and that the settlers who were on the eastern seaboard there and up into Ontario and parts of Quebec, you know, they had their land there, and then the rest of the country, or the rest of the North America, was indigenous. But of course, that all changed, right, with the American Revolution then, and then the founding of Canada. So new treaties came up, and yeah, and then they developed. You know, we did look at how the Indian Act has changed considerably since the mid 1800s. And then the newer acts that we looked at, the Constitution as well. And tomorrow we are going to look at, as I said, there's this video on developing a First Nations Constitution put out by the Center of First Nations Governance uh, nearly 12 years ago. So we will have a look at that tomorrow, and then we will also um, leave you with the key questions for this lesson. So thanks for listening in, everyone. I hope you enjoyed our class, and we'll be back on air again tomorrow. Bye for now.